Hey everyone, my name is Jeff Lee, and I've been handling personal injury and criminal defense cases for nearly 15 years in Memphis, Tennessee. But this is such an unusual time. What happens with COVID when a defendant wants a trial but can't make bond? Do they just sit in jail for years? And also, do the witnesses have to show up, or can they come on something like Microsoft Teams or Skype? And if they do show up, do they get to wear masks? Let's talk about all that in 2 seconds. If a defendant wants a jury trial but cannot make bond, do they just sit in jail for years? Well, unfortunately, the answer is yes. Okay, everyone, that's a wrap. No, but seriously, the unfortunate reality is that if they cannot make bond, they probably have a serious case like murder or kidnapping or rape, and the judge is not going to lower the bond just to make sure the defendant can reach it. I've seen a lot of the easier, smaller cases get worked out in the last year, but some of the more serious cases are just not going to get worked out. This is the timeline for a case. After a person is charged and becomes a criminal defendant, they will receive what's called discovery. And the discovery is everything that the state wants to use against you. It might be witness statements, it might be photos, crime scene evidence, DNA, etc. And after they have gone through all that discovery, they weigh it against the offer in the case. For example, I might think the evidence is really weak, but the stakes are really high. Or I might think that the evidence is strong, so I'm considering this offer I might not have before. So the defendant has received the discovery. They've weighed it against the sentencing range in the offer from the prosecution. And then they say to the judge, I want a trial or I don't want a trial. Now, if a person has received the discovery, looked at the offer, says I don't want that offer and I want a trial, the judge doesn't necessarily lower the bond. The defendant's just going to have to wait until a trial. Now, I'm speaking from Memphis, Tennessee and some of the surrounding counties, but this is also information I imagine is very similar in other states. The judges in Shelby County have said, we are going to try the cases for the defendants that are in custody first. And I think that's the right call. It's not fair if a person is out of custody and they're living their life, even if they're on an ankle bracelet or something like that, they don't get to jump the line from a person who can't make bond but is stuck in the jail with COVID. I know that some of the judges are over 80 jury trials behind. And if you think about the fact that a person in jail is probably charged with something more serious, they can't make bond, that trial could be at least a week long. So if the judge said that he was 52 weeks behind, that would be an entire year. So realistically, these courts may be almost 2 years behind. If a defendant is able to make bond, they're going to wait until everybody in the jail goes first. And they may realistically have a trial that's nearly 3 years away. Okay, now pay attention because these things here are like super expensive. But in July of 2020, in the Court of Criminal Appeals, there was a case called State of Tennessee versus Dennis Lee Seal. And in this case, the allegation is that Mr. Seal burglarized a guy's home and then murdered him. So serious case. The state or the prosecutors wanted to introduce witnesses using Microsoft Teams and Skype. So they were saying that because of COVID and because the witness also had some health issues, it just would not be convenient for the witness to appear. It's not like the defense won't still get a chance to cross-examine her. She will be on a TV screen and the prosecution will ask her questions and then she'll be submitted to cross-examination. and that satisfies the confrontation clause. You probably remember that the confrontation clause says that in all criminal prosecutions, notice this is just criminal, the accused or the defendant shall enjoy the right to be confronted with the witnesses against him or her. Sexist language in the Constitution. But that means that you cannot do it by sworn affidavits. You can't do it by hearsay, where witness A says, well, witness B told me. And you can't do it by confidential informants. So that was the state's point of view. This satisfies the confrontation clause. The defense, now this is the attorney for the defendant, said, well, wait a minute. The Constitution says that I should be able to confront the witnesses face to face. This is not, a case about a dog bite. This is a murder case. And so it's really important. This is interesting here. The court says this is a case of first impression. First impression. And what that means is it's the first time we've seen it. So there are not any case precedents. We don't have a case in the past to talk about what's happened. But what we do have is the Supreme Court of the United States had a different case, different facts, and they're going to decide how close or different the issue in this case is to that. Now, the trial court was the one saying, we agree with the prosecutors, we're going to allow these people to come through Microsoft Teams and Skype. There is a procedure called an interlocutory appeal where you can send an issue up just to review the legality of it. Where is this picture? Here it is. Okay, so here we are can you see that? So here we are in the trial court, and that's in Lewis County, Tennessee. And the case is still pending, but as soon as the trial court judge ruled, I'm going to allow these people to testify this way, the defense attorney said, hold up, wait a minute, we're going to take that issue we're going to take that issue, this is not any better than the last one, straight up to the Court of Criminal Appeals. And we're going to have them decide about whether these witnesses should be able to come and testify virtually. What they say is, let's go ahead and get that issue resolved, and then let's find out if they can come or not. And then we'll come back down to, this is just awful. We'll come back down to the trial court and have the trial. But first we're going to get this ruling from the higher court. Well, what did the higher court say then? They looked at that Supreme Court case that I was telling you about, Maryland v. Craig, and they said, you know what? There's not an absolute right to be confronted by your accuser. And so the court said, we're going to balance the accused rights to be confronted by their accuser and the public policy of requirement of reliable testimony. Because if this child had come into the courtroom, they might have been so flustered that their testimony was not reliable. And so it's a balancing test, hence the scales. So that was the U.S. Supreme Court, highest court in the land. Then the Court of Criminal Appeals that we're talking about, they went back and they looked at, do we have anything in this state that could count as a case precedent? And they didn't have anything that was exactly right. What they had was a case where someone was testifying by like a short circuit television. At the end, they go ahead and said, we're going to send this back down to the lower court. And we're going to say that they need to find more facts out before we can make this decision. So it was of absolute no help They sent it back down without giving an exact answer. They said, you need to get more information. In other words, return to sender. Now, that might have been good if it allowed them to go straight to the trial, but they still don't have these facts. Is it going to be like that Tennessee case where it's going to be so difficult for these people to testify that the judge is going to go back and allow it? Or is it going to be more like the U.S. Supreme Court case? So we'll find out there. But nobody really wants to do a trial right now if they're going to do it twice. This doesn't even go into the all issues with whether jurors will actually show up, whether they'll pay attention, whether they can hear the witnesses, whether they have to have masks on, whether the jurors have to have masks. But this alone, if a trial court cannot get all the witnesses there, there's a real big issue right now about whether they can come by Zoom. This is not as big a problem in civil court because when we talked about the confrontation clause many pages ago, and I'm sure I can't find it right now, but we know that this is only for criminal prosecutions. What a mess. Here we go. This is for criminal prosecutions. So if a person is suing for money, they may still want to have a jury there. They may still have all the same issues with masks, but doctors can testify by deposition testimony. They can come in by video, and that's not really an issue in civil cases. That's one reason that civil cases have been able to continue during COVID a lot better than criminal courts. Does it make sense to have a trial with just the judge, which is called a bench trial? A prosecutor would probably say that's a great idea. A criminal defense attorney would say that's a terrible idea. The only situation I know right now where a person wants to have a bench trial is because that defendant is so certain the witness will not show up that it won't be a trial at all. But if you think about the shared knowledge of jurors, 12 jurors, at least in this state, it's different in others, it only takes one person to say, I'm not satisfied that the state has met its burden, versus a judge. Now, the judge might have been involved in a lot of pretrial hearings. The judge might have completely seen the defendant's criminal history. The judge might have heard that the lawyers have been changing their argument as they go along and see new facts. So the judge really not only doesn't have like the fresh eyes to look at it, but they may have seen things that they bring in that they cannot disregard versus what would happen if a jury came in and looked at it for the first time. Come on. A conversation I often find myself having with criminal defendants or their families and friends is checking on the credibility of a witness. You know, a lot of times somebody says, oh man, this evidence against me is crap. Surely there's some forum where the court can just hear what the witness is going to say now and realize that it's so ridiculous. They just need to dismiss this case. They just need to throw this case out. And what I always tell them is, that's what a trial is. A trial is when the jury comes in and assesses the credibility of all the witnesses. That may be the defendant, but it'll certainly be all the state's witnesses. And the jury decides who's credible, who's telling the truth or not. The judge does not do that job. So when a person says to me, I want to have a hearing with the judge now. I know we can't get a jury for 2 years for a trial, but I want some sort of pretrial evidentiary hearing where the judge will listen to this accuser and just say, case over. But that shows a misunderstanding of the judge's role because the judge is ruling on issues of law. The judge may say this witness can or can't testify, but the judge doesn't say, I think this witness is lying.
No.
Maybe you have a case, you know someone who has a case, or you don't have one at all, and you're just interested in how COVID has affected the court system. I can say, because of the requirement to have all of the jurors come into court, the court system has shown not to be as flexible as a lot of other institutions, and they are really lagging behind, probably for a number of years. There's a famous saying that justice delayed is justice denied, and people say, I want you to file something and say that I have a right to a speedy trial and I want it right now. But I remind people, that motion would be going to the same court that just closed everything down. The state Supreme Court is saying we are weighing the interests of the defendant versus society in general. We're not going to require juries to come in and subject themselves to harm. And honestly, I don't want anybody in a criminal trial for murder and somebody sneezes and I've lost, everybody's attention for 10 minutes. So it's got to be frustrating to sit in jail. You've got a bond you can't make, but you don't want to rush into trial at a time when people are distracted, stressed out, and can't focus on your case. I hope this is helpful. Thank you. If you enjoyed this video, feel free to like and subscribe. And if you didn't like it at all, then tell me why in the comments below. Maybe you have a different opinion. I'd love to make other videos, so tell me what you'd like to hear more about. Yeah, that was supposed to be Elvis. Something happened here, and then it either turned into Ronald McDonald or maybe the Joker. But I drew it poorly just so I didn't get into any copyright issues, and I'm going to stick with that story.